mention, I was mentioning this matter, Your Lordship, today morning, Your Lordship, and I have taken leave from Your Lordship. It is an eviction matter. Notice has been issued to evict the premises by 2nd of May 2025, Your Lordship. Therefore, Your Lordship, I am mentioning the matter. I have taken consent from the state, Your Lordship, mentioning by way of filing.
Please order of eviction.
Yes, Your Lordship. It is enclosed, Your Lordship. Notice was issued on 24th of April and we filed the writ petition on 26th of April, Your Lordship.
ठीक है, इसको अलाउ कर दीजिए। इसका ऑर्डर क्या ड्रॉप करना है?
आउट ऑफ लिस्ट है।
आउट ऑफ लिस्ट।
आउट ऑफ लिस्ट, Your Lordship.
लिस्ट के लिए भेज दीजिए। कब चाहिए?
I mentioned a matter for court number 60 in the morning. Your ladyship asked me to take consent from the other side. I just informed by the office that there is no empaneled advocate for the ESIC.
What?
High Court. There is no empaneled advocate for ESIC in High Court.
Who says so? Who says so?
The office says so. Because they point out defects, what they do is that they point out defects to serve the copy to the other side. In this case, there was no as such defect pointed out by the office. So I went there and
You asked Mr. Ashutosh Kumar. Ashutosh, क्या नाम है उनका? Additional advocate.
Ashutosh
आनंद। आप कोर्ट में रहते हैं, आपको पता होना चाहिए ना कौन कौन सा केस में आप है। क्या हो गया? अटैचमेंट हो गया?
अकाउंट फ्रीज हो गया।
सॉरी?
अकाउंट अटैच हो गया, अकाउंट फ्रीज हो गया। डिफेक्ट्स भी सब क्लियर
अपीलेबल ऑर्डर नहीं है?
है, उसका हम लोग दिए हैं, मैकेनिबिलिटी के स्टेटमेंट्स दिए हैं।
पता है? स्टेटमेंट दिए हैं।
तो बस
अपील में भी तो प्री डिपॉजिट है?
दैट इज
अटैच कब हुआ है?
लास्ट
मतलब डेट बताइए।
नॉलेज में अभी
बहुत अच्छी बात है। फिर क्या चीज़ का मेंशन है? देयर इज नो एजेंसी।
नहीं क्योंकि मल्टीपल अकाउंट्स अटैच हुआ है। मल्टीपल अकाउंट्स
एक ही साथ हुआ होगा ना, सिंगल ऑर्डर से। क्या नाम है ऑर्गेनाइजेशन का?
शोमुख एंटरप्राइजेस।
सॉरी?
शोमुख एंटरप्राइजेस। पिटिशनर जो प्रोप्राइटरी फर्म है उसका नाम शोमुख एंटरप्राइजेस।
कहाँ का है?
ये है कैलकाटा।
प्लेस ऑफ बिजनेस रांची।
हाँ?
प्लेस ऑफ बिजनेस बस इट इज अ गोइंग कंसर्न। इज इट अ गोइंग कंसर्न? क्या करते हैं?
ये मैन पावर सप्लाई का बिजनेस है।
मैन पावर।
हाँ, मैन पावर सप्लाई।
कल करते हैं।
From Supreme Court list for judgment item 1, first appeal 269 of 2023.
This appeal is partly allowed. पोजीशन सिर्फ कंफर्म किए हैं 73 वाले, दूसरे का पोजीशन भी नहीं कंफर्म किया। रिकॉर्डिंग भी आपका अलग अलग है, दोनों में टर्म भी अलग अलग है। टाइटल नहीं एज अगेंस्ट द स्टेट, ओनली एज अगेंस्ट द स्टेट। बाकी आपके सेली पर कुछ कमेंट नहीं किए हैं, ओनली एज अगेंस्ट द स्टेट टाइटल। Sorry? Sorry? Position is yours. Position is yours. जो आपका एंट्री है, मतलब उसको नहीं डिस्टर्ब किया, एंट्री को नहीं डिस्टर्ब किया। पोजीशन है आपका, सो है। I am of the view, just indicating that जब आप सरकार के खिलाफ कोई टाइटल डिक्लेरेशन चाहते हैं तो आपको अपना पूरा टाइटल का बैकग्राउंड देना ही है। प्राइवेट पार्टी के साथ डिस्प्यूट, and this entry has some very strong presumptive value. You have not discharged the owner's requirement. This is
From trading list for final disclosure item 1, second appeal 192 of 2016.
चलिए.
There is no any specific reason assigned by the appellate
For
for
आप पढ़िए जरा ट्रायल कोड चलिए.
right to appellate court.
पहले ट्रायल कोड पढ़िए. What was the suit for? पढ़िए. Specific performance, correct?
Yes. This is suit for special performance of contract for sale with respect to the suit property, more fully described in Schedule B of the plaintiff having area of 700 square feet. In brief, as the plaintiff, Schedule A property which is the house premises more fully described at the foot of the plaintiff previously belongs to and was in possession of Yudhishthir Giri, father of the defendant number 1 and 2, who died on 6/4/1994, leaving behind him his widow and widow Srimati Bhama Devi and 2 sons, Nilanta.
Total consideration was 50,000 rupees,
Yes, ma'am.
right?
Yes, my lord. And
What is the date of agreement बताइए?
1999.
1
Just
13/1/99. That's right. आगे बताइए. What are the issues framed?
Issues in favor of 5 and 6. Whether the deed of agreement alleged to have been executed on 13/1/1999 is genuine, valid, and operative. And 6. It is plaintiff entitled is the plaintiff entitled for the relief of a specific performance of contract for sale or in alternative for a money decree of rupees 45,000 advance to the defendant number 1 and 2 by the plaintiff.
So you made an alternative prayer also for refund of money.
Yes.
What is the finding with issue number 5 and 6?
There is no doubt all the agreement of sale is genuine and valid. So
कहाँ लिखे? कहाँ पढ़े?
page number 22 my lord, in right of agreement.
ये इतना जोर से स्टेपल कर देते हैं, पढ़ नहीं पाते हैं.
Issue number 5 and 6 have been decided first, right below the framing of issues. Reading somewhere else.
ये पढ़ लीजिए इसको. सब पिन निकालना इसको. थोड़ा ना आगे का फाइल्स खोल के देखा कहीं ठीक से खुल रहा है कि नहीं खुल रहा है। जोर से लो। हाँ एलसीएल वाले में तो हो गई,
Just
इसमें मार्क किया हुआ है ना इसमें। जब फाइनली पढ़ते हैं तो फिर पूरा ही पढ़ना होता है, वैसे तो थोड़ा मोड़ा पढ़ना होता तो साइड से थोड़ा छूट भी जाता पढ़ते समय।
what I was submitting just after the issues,
Just
internal page.
after the issues,
Internal page, just below that.
हाँ
They have first decided issue number 5 and 6.
हाँ yes I've seen that।
Page number 22.
हाँ ये स्टार्ट ही किया पेज नंबर 8 से, पहले इशू नंबर 5 and 6
That's
पेज नंबर 22 is the final finding, right?
Yes. It is settled principle of law that documentary proofs shall prevail upon the oral evidence as and in the present suit plaintiff has brought the agreement for sale which has been proved as exhibit 4 and signed of the witness on agreement for sale has been proved as exhibit 4A and 4B by one of the witness of agreement of sale who is PW5 namely Gyan Singh. Not only the expert opinion has also been taken by the plaintiff when defendant challenged the genuineness of agreement of sale. An expert has given their opinion in favor of plaintiff, stating in the court as PW1 that LTI of defendant appearing on the agreement for sale is the same and similar to the specimen LTI of the defendant taken by the court. So there is no doubt at all the agreement for sale is genuine and valid, though the description of sold property is not properly mentioned in the agreement for sale, and in the agreement for sale only 700 square feet land has been mentioned. So land should property, but should property consists of a dual house which is lacking in the agreement for the sale.
No previous partition amongst the defendant with respect to the suit property could be proved.
If the agreement for sale with respect to the Schedule B property has been proved to be genuine and correct by the plaintiff, this fact also appeared to be true that defendant has received advance amount of ₹45,000 from the plaintiff at the time of execution of agreement for sale, which gives support for from the oral evidence of the PW, so that so the court comes to the conclusion that plaintiff at first should get relief of return of advance money given by him to the defendant amount of rupees 45,000 in certain
Agreement is exhibit?
exhibit, yes.
कौन सा exhibit?
Exhibit 4. Description of scheduled property is
Exhibit 4 is the agreement. इसमें भी लिखा हुआ है 45,000 रुपये पाया।
और शेड्यूल ए भी पूरा लैंड का डिस्क्रिप्शन वो 700 स्क्वायर
उससे कोई मतलब नहीं है, क्योंकि आपने तो नहीं चैलेंज किया, ठीक है? वी आर नॉट कंसर्न विद दैट। लैंड के बारे में है, बिल्डिंग के बारे में कोई जिक्र नहीं है। एनीवेज, चलिए ये तो हुआ ट्रायल कोर्ट का, बाकी सब रेडीनेस विलिंगनेस ये सब क्या किए, क्योंकि सूट प्रॉपर्टी बेग है इसीलिए डिग्री नहीं की, है ना? और 45,000 रिफंड का ऑर्डर, ठीक। एपलेट कोर्ट ने क्या किया?
Appellate court, without any assigning reason, they set aside the page number 5, para 10 here, order in appellate court. May I read?
Para 10.
Para 10. From perusal of improved judgment, it transpired that suit has been retrieved and it has been held the plaintiff is entitled to back rupees 45,000, which was paid as earnest money to the defendant number 1 and 2 for execution of sale deed. It has further been held by the trial court. The agreement of sale is genuine agreement. However, plaintiff is not entitled for relief of execution of agreement for sale, but plaintiff is entitled for relief of return of rupees 45,000. From perusal of improved order, a disturbing aspect is noticed by the court, that is at the time of finding issue number 5 and 6. It has been held that there is no proper description of the suit property and there is also no proof of previous partition among the defendants. So, relief of specific performance for execution of sale deed has been denied. However, it has also been held that plaintiff is entitled to get back 45,000 from defendant number 1 and 2, and in case of failure of return 45,000 to plaintiff within 3 months from the date of order, plaintiff would be liberty to get a degree execution through the process.
45,000 plus money just. Just 45,000.
No, the other reasons my learned friend has not read starts from para 7.
You see, the agreement is found to be valid.
No. I'll address your lordship.
No, just a moment. The agreement is found to be valid by the learned trial court.
That is what I was addressing in the first half. Once the trial court has, in issue number 3, trial court has held that the suit suffers from non-joinder of necessary party.
Who was a necessary
Who was the
party?
sister? They said that
Sister means what?
Yudhishthir was survived by the wife and 2 sons, according to the appellant's case. Whereas our case, as upheld by the trial court, is that Yudhishthir Giri was survived by his wife,
The
2 sons,
agreement
and a
was-
sister.
The
Agreement was executed by the 2 brothers only.
An explanation of
No, you
Yes.
see, just a moment.
Yes.
The trial court holds that the suit was there is no partition, right? There is no partition.
No
And the
moral
description, just a moment, and the description of the property is also not there.
Yes,
That
ma'am.
became the reason for
Yes.
not decreeing the suit,
Yes, ma'am.
correct?
Yes, ma'am.
Now, if there is no partition, the partition could not be proved. It is irrespective as to who were the necessary parties in the suit,
Now, because then
and then the agreement was between whom?
the agreement was between the
Plaintiff and the defendant.
2 sons for the share, including the share of the sister. That's why
You forget about it. Who
Because
took the
that's-
money? Who was signatory to the agreement?
the 2 sons,
2 sons.
The 2
They were
sons.
party in the suit.
they were party in the suit.
That's all.
And my lords, my submission would be, like I found one of my lord's judgment has relied last month also. My lord had passed this of 2002 order which says of this honorable High Court, once the necessary party or co-partner, whoever is left out in a agreement for sale, that agreement is void ab initio, it is illegal. So the question would be, my lord, if an agreement is declared illegal for
The
non-joinder,
agreement has not been declared.
that is bound to. Once the court has said that the sister is a necessary party and she has not been joined in.
That was required for the purposes of execution of the agreement. isn't it? She did not join. She did not ultimately join the suit.
My lords.
Correct. That was required. Had the suit been decreed, then you could have said so. But here is a case where the court has refused to decree the suit by saying that there was no partition, and further also said that the description of the suit is not proper.
Yes.
So it was not an executable agreement. That is the reason why the trial court did not agree to that.
As far as that 45,000 amount is concerned,
Just confine yourself to 45,000.
my lords, the appellate court has given 4 reasons. One was no reason assigned in the agreement to sale for selling of that property, which is a dwelling house.
Need not be there.
That the reason which has been assigned by the appellate court, my lords, and
Let us see.
there are 4 reasons. Second reason was, why would someone give a 90% advance, 45,000 out of
देखो ये तो
50,000
absolutely मतलब ये 100% advance दे सकता है कोई.
for an which is unseen, unheard, will not know where.
Why unseen unheard? There could be a reason भाई registrar नहीं है, आदमी
कहीं
नहीं
वो
है.
ऐसा,
ये
there has to be an averment to
not
that effect.
necessary, not
There
necessary.
has to be an averment to that effect.
You
my
see,
lord.
you even disputed the signature over the agreement.
Yes,
That was sent.
it was not a signature, it was thumb impression.
Whatever. That was sent for handwriting experts examination.
No, that thumb impression, yes, but
Yes.
the third reason what the trial court has given is that the LTI was not verified and there was no averment regarding that these illiterate persons were explained, which is necessary part in many
Does
agreements.
the appellate court hold that the agreement is not proved? Does
For
the
these-
finding of the learned trial court that the agreement has been proved has been reversed by the appellate court?
No, on these grounds they said that the 45,000 is not liable. These 4 grounds.
When the agreement is held to be valid,
Manage.
the amount has been mentioned in the agreement also. That is what I checked. It is
but-
not just based on oral evidence.
Yes, no one has stated that कितना पैसा कब कैसे दिया, the clause is there. No one has given the answer. What was the currency? I
इससे
नहीं
क्या
मालूम.
मतलब है? There is a finding on this.
No, if my lord goes to the entire trial court order, the defense was set up, and how these people were trapped into this agreement, everything is there. Therefore, there's a very good reason of doubting the ingredients of this agreement.
Second appeal ऐसे नहीं चलता ना.
Because I'm
Second appeal
limiting-
ऐसे you just address it issue wise, right?
Yes, ma'am.
Whether a proposed seller can take a plea of imperfect title on his part in a suit property in a suit brought against him for specific performance of agreement of sale. Does it arise for consideration?
This doesn't arise, my lord. That's what my first
It
submission.
does not arise.
Yes, my lord.
देखिए पहले.
Second.
Second appeal number 192 of 2016. Learned counsel for the respondent has raised an objection by saying that so far as first substantial question of law is concerned, the same does not arise for consideration in the present case. He submits that the suit was the trial court refused to decree the suit for specific performance of contract, but only directed refund of consideration amount of rupees 45,000. The defendant went in appeal, and the learned first appellate court has set aside the direction for refund of rupees 45,000. And therefore, the first substantial question of law does not arise at all in the present case. Counsel for the appellant does not dispute the opposite submission made by the learned counsel for the respondent. In view of the impugned judgments and the dispute involved, since this court finds that the first substantial question of law does not arise in the present record, and consequently the same need not be answered. Ab second substantial question will come on.
Whether the appellate court assigned any reasons, the 4 reasons assigned, my lord, para 7 onwards, if I
Let us-
can.
What are the 4 reasons for setting aside the refund of rupees?
My lords. Yeah. internal page 4 of the appellate court's order. From the top, it has also been mentioned. Internal page 4 of the appellate court's order. It has also been mentioned that consideration money for 700 square feet land was 50,000 and rupees 45,000 has been paid as earnest money in cash. From perusal of Exhibit 4, it transpired that first party namely Nirantar Giri and Bharat Giri both are illiterate persons and as per deed they put LTI. This agreement is also not registered, rather it is notarized. From perusal of the agreement for sale, it transpired that no reason has been shown for selling of the suit property. Not only this, LTI has not been verified by any person. Not only this, in this case, there is payment of 90% of the consideration money as earnest money, which is not a normal practice. There is no amendment or endorsement on the agreement to the effect that contents of the agreement, which is in English, has been explained to the first party who are obviously illiterate persons. In the bottom of the agreement, stamp which contains execution is known, executor is known to me and signed put LTI in my presence has been put and it bears signature of advocate of Jamshedpur. From the above mentioned discussion of the peculiar facts of the agreement, it is significant that an illiterate person was paid 45,000 in cash by the second party to the agreement. Not only this, there is government that payment of 45,000 was acknowledged. However, I find that no such endorsement has been brought to the notice of this appellate court. Not only this, payment of 90% amount as earnest money is itself very unusual conduct on part of the plaintiff. Not only this, there is a claim on part of the plaintiff who is purported purchaser of the suit property. That suit property has been partitioned among the legal heirs of Yudhishthir Giri. There is no document which shows that the property has been purchased by Yudhishthir Giri. So title of the defendant is also not above suspicion. If there is partition, even among three co-sharers, that is widow and two sons, how a common sale deed was executed without showing individual share of defendant number 1, defendant number 2. Purported common payment to both defendants without individual acknowledgement also makes entire transaction suspicious. As in the case, agreement for sale is in English and purported vendor has put LTI, so there should have been recital that contents of the deed were explained to both the persons and they understood the same. However, there is no such evidence. So far as the opinion of the expert that LTI on the sale deed of the defendant number 1 and 2 are genuine is concerned, it is just an opinion of the expert. Even if I consider that the LTI of the defendant, still in question is whether they put LTI knowingly and with full knowledge about the contents of the document. Being plaintiff, onus lies upon the plaintiff to establish genuineness of agreement which plaintiff has failed to discharge. So I find that deed agreement sale dated 13/1/10 is not a genuine document and there is no proof of payment of 45,000 to the defendants.
What all reasons have been assigned to hold that the agreement is not genuine? What all reasons? Number one, it is not registered.
Well, by the
Need
appellate
not
court.
be. Yes, need not be registered. There is no such law.
Yes. That
For
time-
specific
that time
performance
available.
of
Specific,
contract,
that time available.
Need
About-
not be registered,
about-
right? Number one, not registered. Number two, no reason for selling the property, not required. Correct?
Selling the property which is a dwelling house.
Maybe. One need not give a reason for selling a property. Number three, no averment or endorsement on the agreement to the effect that the contents has been read over and explained to first party. They denied putting the thumb impression completely.
Yes.
It was proved that it was their thumb impression. It is one thing to say that I did not understand, I did not read, it was not read over to me, I have not understood. But they denied execution completely.
And we denied the execution of agreement to sale. It may be that we have taken
That
a.
was not your case.
Yes.
जबरदस्ती कोई हमसे
नहीं, हम वो नहीं कर. We denied the thumb impression on an agreement to sale. In a written statement also we have given certain इनका पहले का क्या था issues. There were certain issues between this appellant and this both families. I don't want to tell you that right now. But maybe during that course उनके पास कुछ paper आया होगा. It may be, but we don't know. We have denied.
assumption जो
नहीं,
चीज़ record पे
but
उसका
what
कहानी
what
में
what my lord just said, we have denied the execution of any agreement to sale. And secondly, receiving any amount. That's what has been denied.
Illiterate persons were paid rupees 45,000 in cash by the second party.
Illiterate persons?
Were paid rupees 45,000 in cash by the plaintiff.
Yes, that's.
मनाही है नहीं दे सकते.
They, but that's the problem. We say we have not been.
Is there any discussion of oral evidence at all?
No.
The trial court has referred to oral evidence.
Oral evidence is fine.
Yes.
That's why I was referring to issue number 3 first. Issue number 3, joinder sister. When the trial, once the trial court has arrived to this conclusion that yes, they had a sister and it was a necessary party, and that issue was against the plaintiff. ये 5 और 6 तो आगे बढ़ना ही नहीं था in view of this judgment में also. Kindly see minutes.
Imperfect title का तो कोई कहानी नहीं है. Imperfect title का तो कोई कहानी
नहीं, imperfect title का अभी तो
कोई कहानी joint property है.
joint property, but that's a data lease property, my lord, but I don't want to go into that right now.
हाँ बताइए.
Let's see. Para number issue frame हुआ था para 12. Second appeal का issue frame हुआ था same. The two brothers, one of the brother has executed. Advance भी था इसमें लिया हुआ. Second appeal was admitted on the following subsection. When admittedly exhibit A sale deed standing in favor of the appellant was executed by Chetu defendant number 1 and his brother Ketu claiming the property to be their joint property. Whether in this suit in absence of Ketu, any finding could have been recorded that property exclusively belonged to Chetu who had entered an agreement to transfer the
ठीक है.
property.
No finding can be recorded that it is his exclusive property. Fair enough.
Yeah, but then
But
what?
when there is a monetary transaction in connection with the property.
Here also there was, my lord.
No, that was not the question of law frame.
No, but what my kindly similars, para then 13 we may skip, para 14. In such circumstances, in my opinion, the Court of Appeal below committed a mistake, especially in absence of Ketu, but when recording a finding that premises in question exclusively belong to Chetu defendant number 1 Once it was established that the premises was joined between two brothers, Chetu and Ketu, then Chetu alone had no right to execute agreement of sale in favor of plaintiff. The said agreement for sale was invalid and was not enforceable.
That's right.
So, my lord,
If
that
it is an invalid, then equity will come into picture that you have taken money. How is it possible that you will retain the money and then say the agreement is invalid and not, and they had made an alternative prayer also for refund of money?
Lords, they have made that alternative prayer in view of that agreement.
Yes.
So once it is held that that agreement itself is invalid,
So,
can they stand for that 45,000?
yes, certainly.
Then, my lord, I don't have any. That's my own. Once it is held that the agreement is invalid, how can you bifurcate an agreement?
And there is no discussion, no iota of discussion also of the oral evidences which was the basis for decreeing the suit. And that is why this substantial question of law has been framed.
Second one.
Yes, whether the first has assigned the specific reason for setting aside the finding of the learned trial court. No reason has been assigned. The trial court finding is based on oral evidence. There is no discussion of oral evidence by the first appellate court. A में पहुंच गए.
That is not.
He is only concerned with the finding that there is no proof of payment of 45,000. बस उसी से मतलब है. This finding is perverse because there is oral evidence to support this finding, as per the trial court judgment. Bharat Giri is a signatory to the agreement.
The
Bharat?
other brother,
Bharat?
yes. Yes, ma'am. Other brother. There are two brothers.
उसको बोल रहे हैं पागल है.
Yes, ma'am. That was the
Proof की.
proof नहीं हो पाया. There was no document. वो बचपन से ही था. That's what I plea. There was no document to that effect. Deposition से there.
कहाँ से क्या किडनैपिंग का कहानी क्या क्या चल रहा है इसमें?
That's what I said, but I don't want to delve into that. The appellant who had filed the suit earlier, he was a Baba. So,
Appellant was a Baba.
the appellant, plaintiff, he was a Baba. So, and he was somehow tangled with wife of this Nirankar Giri. Wife of the Nirankar Giri, she was a vegetable seller. And it is admitted now that she has filed a case against this Baba. The son admits. Son of the Baba is no more now. Son of the Baba who has deposed, he admits that yes, the wife of Nirankar Giri, she has filed a case against that Baba.
इससे क्या मतलब?
I'm just
हाँ, that is a story.
not the relation is now admitted, and that's why there were previous history here, my lords. Who used that paper and what?
question of law is whether the first appellate court has assigned the specific reason for setting aside the finding of the learned trial.
My submission would be specific reasons are there, but whether valid or not, should have been valid reasons. They are assigning specific reason, whatever the court felt the specific reason they are given, 4 to 5. Why we are not inclined to go with that 45,000? Whether those reasons are valid or not.
No, you see, trial court has recorded that the agreement is valid in the sense that was executed, right? But it is not valid because there is no proper description of the suit property. And while doing so, the trial court also took into consideration that the handwriting expert was matching, the evidence of handwriting expert was matching, or fingerprint expert was matching. The appellate court taken the evidence of the handwriting expert into consideration by reversing the finding into that effect that the agreement was invalid?
As far as I know,
And has the appellate court considered any of the oral evidence? Throughout, the court has not considered any of the oral evidence. On the other hand, the trial court considered both oral and documentary evidence with regard to execution of the agreement. So, this finding has not been actually met with by the appellate court, as the discussions, oral evidences has not been considered at all. दो आदमी बोल रहे हैं कि मेरे सामने एग्रीमेंट हुआ, काफी है, if remains proved. If that is proved and remains unproved. लेकिन appellate court का कोई discussion ही नहीं है, हम इतना देर से वही देख रहे थे. Oral evidence का कोई discussion नहीं.
neither PW, DW किसी.
तो इस circumstances में हम यहाँ पर बैठ के हम discuss करके तो नया finding नहीं record करेंगे ना, because there is no discussion. I have no option but to remand this matter on this point. कैसे होगा? बताइए कैसे होगा? यहाँ पे थोड़ी फाइंडिंग हम रिकॉर्ड कर देंगे. भाई एपलेट कोर्ट ने डिस्कस नहीं किया फाइंडिंग्स, ठीक है, ओरल एविडेंस नहीं डिस्कस किया व्हाइल रिवर्सिंग द डिक्रीमेंट. तो हम यहाँ पर सेकेंड अपील में बैठ के ओरल एविडेंस डिस्कस करके एक फाइंडिंग नहीं ना रिकॉर्ड कर देंगे. यहाँ पर देयर इज लॉट मेनी ओरल एविडेंस, एक नहीं है, बहुत है. तो सीधा सीधी हुई है ऑर्डर 41.
What my lord said in that, my humble view will not make it suffice.
है नहीं?
I don't know.
क्योंकि अभी हम यहाँ पे
For me
कैसे
to meet the ends of
बोलेंगे?
justice, my lord.
उस पॉइंट पे डिमांड करना. Has not discussed any
Any
of
of
the
it.
evidences. देखिए सेकेंड अपील नंबर अभी पार्ट लिखाए थे.
Yes.
आपको लिखाए थे. So far as the second substantial question of law is concerned, the learned counsel for the appellant has submitted that the learned trial court has considered both the oral and documentary evidences on record, while holding that the agreement was executed but declined to decree the suit for specific performance of contract on the ground that the description of the property in the agreement was not proper. The learned court also referred to the oral evidences on record and came to a finding that that there were oral evidence with regard to payment of rupees 45,000 as earnest money. He has submitted that the learned first appellate court has not at all considered the oral evidences and has recorded a finding that the agreement that the plaintiff could not establish the genuineness of the agreement, and further recorded that since the agreement for sale dated 13/1/1999 was not genuine document and there was no proof of payment of rupees 45,000 to the defendants. He submits that none of the oral evidences having been discussed by the learned appellate court and the finding of the learned trial court being based on both oral and documentary evidence, and the learned appellate court has not assigned the specific reason for setting aside the finding of the learned trial court with regard to the legality and validity of the agreement. He submits that the substantial question of law be answered in favor of the appellant and the appellate court's judgment be set aside. A. The learned counsel for the respondent has submitted that has also not been able to point out any discussion of the oral evidence from the perusal of the entire judgment passed by the learned first appellate court. Although admittedly there were both oral and documentary evidences led by both the parties. He submits that at the second appellate stage, the evidences may not be appreciated to come to a finding, and at best it is a case for remand. He submits that he has referred to order 41 of CPC. After hearing the learned counsel for the parties, बाकी remand का order होगा. ठीक है? We have passed a few orders. और कोई डेट फिक्स करेंगे फॉर योर अपीयरेंस, हाँ, बिफोर द लर्नड फर्स्ट appellate.
Also give a direction within a specific.
हाँ, I will do that. डेट अपीयरेंस का डेट फिक्स करना है. वो हम लोग एक जजमेंट किए थे शर्मा जी के केस में. शर्मा जी आपके किस केस में किए थे? 28 की 31 ऐसे किसी. हाँ, 28 of 2007. ठीक है. जजमेंट ऑफ रिवर्सल है तो रीजन और एविडेंस पूरा ही कंसिडर करना. ठीक है. वही हम देख रहे थे कि हम यहाँ एविडेंस कितना हम देखेंगे. देयर आर लॉट मेनी एविडेंस, ओरल एविडेंस. क्रॉस भी अच्छा है सब. अच्छा खासा क्रॉस.
That's why I bow down to view that is the only possible solution.
ये है क्या? ये 192 है. किनका?
जितेंद्र उपाध्याय.
नहीं, ऐसा नहीं कर सकते.
अभिषेक मेरा के नाम है.
ये सिर्फ आपकी का ऐसा नहीं हो सकता.
For hearing item 6 second appeal
जो आपके
307
नहीं
of
हुए
2016.
उनका अपीयरेंस नहीं रिकॉर्ड कर सकते हैं. हम लोग को झूठा मत बना दीजिए. हाँ? हमको तो कभी कभी लगता है कि जिन लोगों का कभी कभी अपीयरेंस रिकॉर्ड हो जाता है क्योंकि वो स्लिप दे देते हैं, लेकिन अगर कोई हमसे पूछेगा कि ऐसे कोई अपीयर हुए थे कि नहीं हुए थे और वीडियो देखेगा तो हम उसको क्या जवाब देंगे. और आपके लिए बहुत अच्छा ऑर्डर, आप केस जीते हैं, हारे नहीं हैं, ठीक है, इसीलिए आप खुशी खुशी जाइए। Yes. बताइए सब्सटेंशियल क्वेश्चन ऑफ लॉ क्या है? सॉरी
5th of February 2019, order number 7.
5th of February
Whether the position of the defendant has not ever been considered by the court or the judge.
ऐसा कैसे? दोनों ने कंसिडर किया, इशू फ्रेम हुआ,
Issue friend,
दोनों कंसिडर नहीं
not
किया।
considering.
कौन है रिस्पॉन्डेंट? Nobody.
Plenty. Suit was decreed.
Possession is an important right.
एक पॉइंट ऑफ लॉ और भी है हमें इस केस में लिबर्टी मिली है।
कहाँ लिबर्टी?
सब्सटेंशियल क्वेश्चन ऑफ लॉ इफ एनी
अब
सच
क्या?
लिमिटेड इन द टाइम ऑफ ये तो इसमें पॉइंट और है जो कि इसको फ्रेम किया जाना चाहिए। वो पॉइंट ऑलरेडी हमने फ्रेम किया। At page 15, whether the learned appellate court while passing interim judgment and decree also failed to appreciate that title suit number 27 of 2007 was itself barred by the law of limitation as plaintiff has intervened in miscellaneous case number 13/19/394 but has instituted the suit for declaration of his right at his interest in confirmation of possession in the year 2007. Immediately after lapse of prescribed period of petition. कोर्ट ने इसको आंसर किया है कि हाँ WPC में आए थे, फिर PM में आए थे, लेकिन जब एक बार आप इंटरवेंट कर जाते हैं तो फिर तो लिमिटेशन तो 13 साल का हो जाता है। तो इसमें 93 का इनका डेट है और 2007 में फाइल किया इमीडिएटली बाद लिमिटेशन।
ये सूट में क्या था? मिसलीनियस केस में?
जी
मिसलीनियस केस में क्या था?
इसमें
मिसलीनियस केस में क्या था?
miscellaneous केस में cancellation of demand. Cancellation of demand was allowed. That has traveled up to LPA. तो LPA कोर्ट ने इन्हें लिबर्टी दिया, rather एडिशनल कलेक्टर का ही कोर्ट इनको लिबर्टी दिया था, प्रेफर सूट। तो सूट किया भी इन्होंने, लेकिन इंटरवेंट कर गए थे जब 93-94 में। तो नॉलेज तो हो।
इंटरवेंशन अलाउ क्या?
हाँ इंटरवेंट किया।
इंटरवेंशन अलाउ हुआ,
लेकिन इंटरवेंट नहीं किया। He had the knowledge.
ठीक है, नॉलेज,
Knowledge था।
but he was pursuing his matter.
इंटरवेंशन जब अलाउ, मान लीजिए आपने पिटीशन फाइल कर दिया तो कैन यू से दैट आई हैव नो नॉलेज।
सूट में
अलाउ
सेक्शन
हो जाए
14, सूट में सेक्शन 14 का बेनिफिट मिलता है कि नहीं?
सूट में सेक्शन 14 का अमेंडमेंट इसमें नहीं मिलेगा। प्लीडिंग्स के आधार पर अगर आप प्रे करते हैं वैसा एविडेंस लाते हैं कोर्ट उसको कंसीडर कर सकता है।
कोर्ट तो वही ना कंसीडर किया है।
सेक्शन 5 का
5 का तो नहीं मिलेगा, 14 मिलेगा कि नहीं? तब तो यहाँ जो 20-20 साल बाद डिसाइड होता है कि आप जाके टाइटल सूट फाइल कर
नहीं,
दीजिए।
उसमें अगर ड्यूटी ग्रांटेड, अगर कोई सूट आपने फाइल किया है उसको कोई प्रोसीडिंग में लिबर्टी ग्रांटेड है।
प्रोसीडिंग में तो है ही,
सूट में अगर कोई लिबर्टी
सूट में नहीं। बात यह है कि जब वो अपना वो म्यूटेशन या जो भी प्रोसीडिंग में वो लड़ रहे थे,
हाँ
अल्टीमेटली तो डिसाइड हुआ
नहीं,
उसका
लेकिन आप इस तरह से टाइम बाय नहीं कर सकते। डिक्लेरेशन ऑफ टाइटल के लिए तो आप नहीं आए थे, आप आए कैंसिलेशन ऑफ डिमांड पर आए। कैंसिलेशन
फर्स्ट क्वेश्चन ऑफ लॉ क्या है? इतना जनरल है, वो खाली देखा जाए।
हम देख लिए।
हाँ,
लेकिन पोजीशन की पड़ता दोनों कोर्ट
पोजीशन का इशू बना है,
हाँ बना
तो क्या हुआ? कुछ तो लिखे होंगे ना कि नॉट प्रेस्ड।
दे लिखे हैं कि
नॉट प्रेस्ड लिखेंगे तो फिर बस बात खत्म हो गई।
लिखा
ऐसा नहीं हो सकता है कि कुछ ना लिखे हो।
ट्रायल कोर्ट
मेरा पोजीशन डिक्लेयर हुआ है,
आप दिखाते हैं ये ट्रायल कोर्ट का जजमेंट देखिए इशू देखा जाए तो 12 में whether suit is brought by law of limitation, regular estoppel, acquisition, and adverse clause. Issue number 2. इसका फाइंडिंग देखा जाए at page 18, internal page 18, para tech. Defendants have taken plea that suit is barred by law of limitation, regular estoppel, acquisition, and adverse clause. As per defendants, plaintiff has purchased the suit in the year 1993. Thereafter, plaintiff shall file the suit on the basis of the purchase credit to declare right, title, interest, and possession after 14 years, whenever limitation act should be applied within 12 years. Although it is true that plaintiff have purchased the suit land in the year 1993. Thereafter, suit has been filed in the 2007. Thereafter, miscellaneous case was pending in the court of CO and RTC and after 1993, appeal was preferred with an additional purpose and revision was filed which was dismissed. And thereafter, plaintiff and others have filed writ application in the year 2004. Thereafter, plaintiff shall prefer appeal before the division bench with a direction to approach civil court of competent jurisdiction of education act. Hence, thereafter, the suit was filed in the year 2007. Hence, as per Limitation Act, while continuing computed the period type by elapsed in the legal proceedings should be issued. Hence, plea of
लिमिटेशन तो नहीं है लेकिन पोजीशन का फाइंडिंग का
कुछ
कहाँ है
भी-
बताइए पोजीशन का फाइंडिंग
हाँ फाइनली है
बताइए
पहले
दूसरा
trial-
जगह कर दिया है क्या
हाँ हाँ ट्रायल कोर्ट का पहले देखा जाए इशू नंबर 7 राइट टाइटल इंटरेस्ट एंड पोजीशन एंड देन
जस्ट अ मोमेंट इशू नंबर 7 में डील की
हाँ
राइट टाइटल इंटरेस्ट
एंड पोजीशन एंड ये इसका
Issue number
फाइंडिंग है
7 का फाइंडिंग
फाइंडिंग इशू नंबर 7 का फाइंडिंग हम दिखा रहे हैं पेज 17 इंटरनल पेज 17 ऑफ द ट्रायल कोर्ट आफ्टर 2 paragraphs on perusal of this order it appears that the defendant have not filed sada deed which sada will that is actually will whenever plaintiff had filed a copy of mortgage deed hence as per this order of name of Gopal Mahto are mentioned in register 2 and he is in possession over the suit land also. But despite this land, demand has been cancelled in the name of suit. So although I was found to be in possession, my demand was cancelled. Page 17.
फाइंडिंग स्पेसिफिक फाइंडिंग है कि पोजीशन में कि हम है पोजीशन आज भी
और कैसे स्पेसिफिक होगी
And therefore,
because it says that in spite of the fact that he is in possession the demand was cancelled
नहीं इसमें लिखे हैं पे डिफेंडेंट्स आर आल्सो इन पोजीशन उसी का
कहाँ defendants
para
are
सेकंड पारा पढ़ा
दो आदमी कैसे प्लेंटिफ डिफेंडेंट दोनों
हम
पोजीशन
पोजीशन में है एक्चुअली
कहाँ
ये कोई
है
document-
कहाँ
हमारा-
डिफेंडेंट इज इन पोजीशन
on perusal of CO it appears that granted rent
it has also been stated.
as per the registered to the name
Then
of
he
Gopal
gives
Mahto.
his finding.
That is part of
and
the
hence
second-
as per this order the name of Gopal Mahto as mentioned in register
defendants are also
and he is in possession over the suit land also defendant क्या was defendant
defendant और हम ही हाँ, ये plaintiff
नहीं नहीं ये जो है ना आपका डिफेंडेंट ने कोई डॉक्यूमेंट नहीं फाइल किया है बिल्स में एंड देन द कोर्ट इज रिकॉर्डिंग अ फाइंडिंग दैट ही इज इन पोजीशन प्लेंटिफ इज इन पोजीशन
नहीं ऐसा नहीं लिखना है डायरेक्ट कहाँ पुलिस वाला
ये पारा ये पढ़िए on perusal. On perusal of this order,
On
it
perusal
further
of this
appears.
आप देखिए ना उसके ऊपर देखिए ऑन पेरुसल ऑफ द ऑर्डर ऑफ सीओ एग्जिबिट जी
the defendants have not filed deed
नहीं उसके ऊपर पढ़िए ना उसके ऊपर ऑन पेरुसल
on
एक और
perusal of CO
हाँ
it appears that he has granted rent receipts from 93 to 94
73 to 70
74 as per registered to is in the name of Gopal Mahto
हाँ गोपाल महतो कौन है गोपाल महतो
Gopal Mahto तो
प्लेंटिफ है ना
plaintiff to purchaser
हाँ,
वही एक ही बात है
हाँ,
कर्जा
yeah, from the sons of Gopal
Yes.
Mahto we had purchased.
तो और क्या चाहिए?
नहीं और भी लिखा है. It has been also stated in some part of the खतियान, खाता नंबर 17, second party is also in possession. उसी रिपोर्ट में लिखा हुआ है. इसी रिपोर्ट के आधार पर कोई टेक्निकल फाइंडिंग देना चाहिए. उसमें तो इशू नंबर 2 में
Yes, yes.
कुछ नहीं
Now,
दिया.
now, I recollect. Now, interestingly, entire case would be he purchased from the same Gopal Mahato and his family. He himself purchased. That means they themselves have purchased certain property from the same, from our
Because
vendor
of
itself.
which they are in possession of
Yes,
the property.
yes, absolutely.
Which is
And
that
therefore,
Henrik?
That is the exhibit 4 by A. And that would be the crux of the entire. So if he challenges the entry made in my favor, my vendor's favor, then he also purchased the property from the same vendor. So now he could not have said that now my vendor did not have any.
Whole property is 2.12 acres. Or they have also compromised with this petition, these defendants also. Those are also on record. Compromise, there is a relinquishment deed, registered relinquishment deed is also, that is also on record.
After
I
transferring
am here
the
in
property
possession.
to me in '93, my vendor executed a relinquishment deed in the favor of the.
Though there is no categorical finding that who is in possession. Appellate court has also not ruled.
What is the suit land?
Suit land is 2.12 acres of land.
ऐसा नहीं होगा. आराम से एकदम
हाँ.
आप एक जने बैठ जाइए और आराम से बोलिए सूट लाइन को समझिए. What is the suit line? Schedule A property.
Schedule A. Khata number 17.
All from khata number 17.
And one also from another also, that is 19, that is 0.02. Total 2.1.
Khata number?
Khata number 9, khata number 19.
Khata number 17 and 19.
No.
So,
2.10 of khata number 17, 0.02 of khata number 19. Total is 2.1.
2.10 is khata number 17. 0.02 of khata number 19. Correct?
Correct.
Total area is 2.12. Schedule B is the genealogy.
Genealogical.
Lalit Mehto had two sons, Panur Mehto and Gopal Mehto, alias Yadav.
That is there.
Vendor. Where is the plaintiff? In genealogy में plaintiff कहाँ है?
Plaintiff नहीं है, इनका purchaser है. Plaintiff ने purchase किया है जमीन.
इनसे.
इनसे वही गोपाल महतो recorded tenant, so far गोपाल महतो का recorded tenant के वारिसान से purchase किया.
अच्छा, plaintiff ने purchase
Plaintiff
किया.
ने purchase किया. He is a purchaser.
Okay. और आप कौन हैं?
हम कह रहे हैं कि हम ओरिजिनल डिसेंडेंट्स हैं और
किसके?
हम दमन महतो के डिसेंडेंट्स.
दमन Mehto तो कोई नहीं है यहाँ पर.
दमन महतो ओरिजिनल रिकॉर्डेड टेनेंट के ब्रदर, दैट इज आवर केस.
ललित Mehto के brother.
हाँ, brother.
ऐसा तो कोई genealogical
ये है, इसमें हम लोग इनका रिलिक्विशमेंट डेट है रिकॉर्ड पे, उसमें भी ऐसा आया है और कोर्ट ने हालांकि इसे डिसबिलीव किया, जो कि नहीं करना चाहिए था. दैट वाज रजिस्टर्ड डॉक्यूमेंट. इसके बावजूद भी लेकिन पोजीशन का जो मेन इशू है, पोजीशन में कोई फाइंडिंग इनका नहीं है. इनका हम पोजीशन हम दी
इन्होंने जो प्रॉपर्टी परचेज की है,
जी.
ये पूरा सूट प्रॉपर्टी इज परचेज्ड बाय देम. द एंटायर सूट प्रॉपर्टी इज परचेज्ड बाय देम.
2.1
2.12
8.8 and odd.
खाता नंबर 17 का टोटल एरिया है 0.06 एकर्स.
नहीं, इसका टोटल एरिया 8 पॉइंट एंड ऑड
8.1.
8.35.
जिसमें ये 2.10
इसमें तो दिखा रहा है शेड्यूल में 8.12.
8.1 जिसमें ये 2.10 परचेज.
ठीक है। और पार्ट 2 का खाता नंबर 19 का दिखा रहा है 0.24 इज अ टोटल एरिया। अब जरा रेस्पेक्टिव केस बताइए पार्टीज का।
As per the plan, para 2 देखा जाएगा.
All the recorded radius entered into amicable oral partition of the land of खाता number 19.
17 का area 8.34 acres से लिखे. It was recorded in name of one Lalit, son of Guru. By the rating in the last survey settlement and 19, खाता number 19, plot number 318, area 0.24 acres of village Pachmo stood recorded in the name of Salim. One share Ram Punya and Jago Punya, one share Pakistan Barabar and Lalit Mato, son of Guru Mato, one share and all enforced recorded areas and partition Mata of 19 and morally accordingly share of Lalit Mato measuring an area of 0.08 West Park. Recorded area Lalit Mato has two sons, Pannu and Gopal. Pannu Mato died since. As such, Gopal Mato inherited the entire land of Lalit Mato by way of survivorship. Gopal Mato had 4 sons, Haro, Samar, Budan and Heman. Haro Mato died issueless. As such, his share was devolved upon the remaining brothers who had been paying rent to the estate of Bihar. A genealogy has also been made. Further case of the plaintiff that he has purchased 2.10 acres pertaining to Khata number 17 and 0.02 acres pertaining to Khata number 19, plot number 318, both for village Pachmo, total 2.12 acres by virtue of registered sale. So, here 3091 of from the legal heirs of recorded tenants, Sobha Mato, Udan Mato, Haman Mato, all sons of people, came in possession thereof, but the defendant started to disturb the possession of the plaintiff on the basis of concocted in the Nari story. Udan Mato, husband of defendant number 3 and defendant number 4 to act and also purchased land out of suspension and by registered deed and came in possession thereof. Said Udan Mato had filed a petition for cancellation of demand running in the name of the Sumar Mato enterprise, जिससे परचेज किए हैं उसका cancellation of demand के लिए ये petition था running in the name of Sumar Mato with respect to खाता number 17 of village Pachmo before CO who recommended for opening of Lemabandi in the name of the aforesaid Dukan Mato and sent the record to SDO Chadra, which was forwarded by LRDC. White miscellaneous case number 6. Plaintiff also filed an intervention petition before the Chadra to set aside the order of LRDC on 13/11. तो ये इन्होंने इंटरवेंशन पिटिशन फाइल किया, उसके बाद ये ऑर्डर सेट असाइड हुआ. Said Dukan Mato preferred an appeal against the aforesaid order of SDO before the additional collector. White miscellaneous case number to reverse the order of SDO. Plaintiff preferred revision against the order of additional collector before commission. While revenue revision case number which was dismissed with observation for filing title before the competent court. Plaintiff and others have also filed WPC before the Honorable High Court of Jharkhand, but the same was dismissed with a direction to approach competent civil. The plaintiff and others again filed an appeal before the division bench, which was also dismissed with the direction that parties have already directed to approach the civil court of competent jurisdiction. Thereafter, they instituted this. This is their case. Defendant 228 appeared before the trial court and contested the suit by filing joint written statement disputing the claim of the pleaded that the suit land held by them.
What about the appellate court?
जी
Appellate court?
appellate court ने भी कुछ नहीं किया, यही order है exact.
Your Lordship, both parties are differing in genealogy. It is handwritten genealogy if Your Lordship would see this. It would
टर्मिनोलॉजी से
easier,
नहीं है,
it would be
क्योंकि
easier.
हमारा क्वेश्चन ऑफ लॉ बहुत लिमिटेड है.
नहीं लेकिन एक देख के खाली समझने के लिए हम नहीं बोल रहे हैं इसको ये इजी होगा, अदरवाइज फैक्ट में वो तो
फैक्ट में हम कुछ लिखाएंगे ही नहीं.
ठीक-
अगर आप
ठीक है.
हमको पोजीशन में कोई फाइंडिंग नहीं दे पाएंगे तो हम क्या करेंगे?
नहीं पोजीशन में तो हम दिखा दे रहे हैं, हम तो दिखा ही दिए पोजीशन.
नहीं, उतना फाइंडिंग इनकम्प्लीट, इनकंसिस्टेंट.
नहीं
इतना
inconsistent.
पूरा मतलब पूरा रिकॉर्ड में क्या ही फाइंडिंग है वो. लिखते ना कि भाई इनका पोजीशन है और इनका नहीं है, ऐसा तो कुछ नहीं है. खाली वो जो प्रोसीडिंग हुआ है उसके बेसिस पे रजिस्टर्ड का कहानी लिखती है, वही तो डिस्प्यूट में था.
तो उसी आदमी से मेरा अगर वेंडर जो है उसी से ये सेल डीड लेकर पोर्शन ऑफ द प्रॉपर्टी ही इज क्लेमिंग पोजीशन ऑन अ पोर्शन ऑफ इट. सो रेस्ट
He is
ऑब्वियसली जो
claiming-
हमको ट्रांसफर हुआ है वो मेरा पोजीशन है.
ऐसे ऑब्वियसली तो नहीं होता ना. पूरा प्रॉपर्टी का कुछ पोर्शन इनको ये खरीदे, कुछ पोर्शन आप खरीदे.
नहीं, एक ही वेंडर ट्रांसफर सर्टेन पोर्शन टू हिम,
इनको
सर्टेन
कितना बेचा?
हाँ,
इनको कितना बेचा
इनको बेचा है
और कौन बेचा है?
मेरा वेंडर. यही
नाम
तो
बताइए.
हाँ, नाम बता. सोमर Yadav, son of Gopal Yadav. Sometimes they have written Mato, at times they have written Mato. And the khata number is 70. Same khata number which ultimately it has come that in some portion they are also in.
सब पोर्शन बोलने से नहीं होगा ना. सूट प्रॉपर्टी का प्रॉपर बाउंड्री दिया हुआ है. सम पोर्शन बोलने से कैसे होगा? कोई क्लियर फाइंडिंग नहीं. इट इज नो फाइंडिंग. किस तरह का फाइंडिंग है ये बताइए. I don't see it as a finding.
लास्ट में भी appellate court ने लिखा है कि in view of the assessment of evidence on record, therefore the Honorable court has minutely scrutinized the evidence on the record and arrived on the said finding that vendor of the appellant has the right title and interest का लिखा है. पोजीशन भी तो नहीं कहा, यहाँ भी तो नहीं कहा, कोई फाइंडिंग नहीं है.
पॉइंट ऑफ डिटर्मिनेशन क्या बना?
कोई पॉइंट ऑफ डिटर्मिनेशन भी क्लेम नहीं. यही ट्रायल कोर्ट को लेकर आगे बढ़े और 41 रूल का जीवन का कंप्लायंस भी.
ऐसा तो नहीं होगा, कुछ तो बना होगा. पैरा 18 में देखिए तो क्या है?
है हम सिर्फ जगह निकाल.
पारा 4
Para 10. Para 9 he says heard argument on so and so. Now para 10, now there is only one question which emerges from the rival submission as to whether the impugned judgment and decree passed by is justified, legal and just. So
जनरल टाइप कोई स्पेसिफिक पॉइंट ऑफ डिटर्मिनेशन थोड़ी.
पॉइंट ऑफ डिटर्मिनेशन
ठीक है, but he frames it. It cannot be said that he did not frame it.
Just for
And for concurring with the trial court judgment, he is not required to specifically say that no, this is the. He finds and he gives finding with regard to all. He discusses everything.
अब जरा पैरा 8 देखिए. अब द appellate court judgment.
Alright. Being aggrieved and dissatisfied with his due judgment and decree, the learned lawyer appearing on behalf of opponents has mainly extract issue number 7 and draw my attention towards the reading of the parties and written schedules. Learned lawyer has further given much emphasis upon the finding divide. Learned and submitted at under trial court at the time of deciding issue did not consider documents being disputed by defendants. Such and such. He also did not consider peaceful position of defendants over the suit land. Hence, the judgment and decree of the suit court below is bad in law and fit to be satisfied. पोजीशन का तो इशू हम उठाएं. Absolutely, there is no funding available.
Appellate wrote a finding लिखा है possession. He has raised an issue on possession. He has raised an issue. Where is the finding of possession by the appellate?
Our 21 will be funding. Position लिखे थे.
ये relinquishment deed is a registered deed.
But after my sale deed. My sale deed is of the year 1993. After that, the my vendor, he executes a relinquishment deed, says that he did not have any right whatsoever on the property.
पैरा 18 देखिए, फाइंडिंग पैरा 18 में ही है. लिखा है पोजीशन का फाइंडिंग है. एडवर्स पोजीशन का भी कुछ भी लगता है, कुछ प्ली रेज हुआ होगा तभी इशू भी बना था, उस पर भी कोई फाइंडिंग.
To adverse possession, then he has to first say that he is in possession.
पोजीशन पे कोई फाइंडिंग ही नहीं है.
उसके लिए नहीं. His whole case, if you look at whether this particular issue was required to be decided by the appellate court or not, my contention is absolutely different. What is his claim? He says that original recorded tenant had he died issueless and he had a brother whose name is nowhere He claims that he had a brother and they are descendants of that brother. And interestingly, they also say that in 1925, that recorded tenant had executed unregistered will in favor of his brother. So both the things, if he was issueless, then obviously the property would have
Registered will, will without probate.
without
will have
probate.
No meaning.
So that is one of the finding.
Will without probate is of.
That is one of the finding. Now his whole case is dependent on 2-3 things which are absolutely
Now he is claiming inheritance.
Inheritance.
Irrespective of will.
so he cannot take 3 different stands.
No, there can be a will in favor of a legal heir. Is there any bar?
No, it has not been, but no
It
probate
is not
was there.
conflicting. That's
No
right. You
probate
forget
was
about
there.
the will.
So absolutely that is, now your lordship may see that he says that he is claiming by way of inheritance. So inheritance to whom? He has to say that if he did not, if we did, therefore I was showing
No,
this.
we are only concerned with the question of loss of freedom. There was an issue framed regarding possession at 2 places. One was regarding adverse possession and another was, you have shown that in this particular. So far as the trial court is concerned, there is a dispute between 2 of you as to whether that can be said to be a finding. And so far as the appellate court is concerned, the issue was raised that there is no finding regarding possession. But there is no finding.
But whether your lordship, if substantial question of law, if the otherwise the suit is, I can show that the suit was rightly decreed and impugn judgment only merely because this particular finding was not there, that would not make the entire judgment, because
No, we will not set aside the entire judgment. But the
ultimately he is
finding
not-
of possession has to be there.
But-
A person may be in illegal possession of property.
But
He may be in forceful possession of property. He may have no other title, but he is just in possession of the property. There are so many kind of possession. Constructive possession, ho sakta hai. You do not know what kind of possession we are talking about. But once an issue is raised that yes, he is in possession, the issue is framed, whatever decided, not decided, raises an issue before the appellate court also that my possession has not been considered and the appellate court is completely silent on possession. How do you view this as an appellate court?
because otherwise his whole case was dependent. Whatever case was he pleaded before the court, entire thing was discussed and it said that he did not have any right whatsoever. So he did not have any right, and then there is an he comes
He
to the
must be
conclusion.
a trespasser. He is nobody. Let us assume it.
But he is concurring with the judgment passed by the trial court. Trial court says that he is in possession. We are in possession. That finding is there. And whatever finding is there with regard to the defendant, that obviously is based
Even
on
while conquering a finding, one word to आना चाहिए.
वो ठीक है.
Final भी क्या है?
इनका-
No right, title and interest. The
इनका-
word possession is very consciously omitted.
हम दूसरा चीज. You know, Chip, his whole case is on the basis that he had the original recorded tenant did not have any successor. He died issueless, and I am the brother,
That's
and
right.
from that I am getting. Now both the courts have concurrently found that he did not die issueless and he had issues. And then we are obviously, my vendors were the persons from whom
You have purchased.
yes, and from the same vendor they also purchased. So here the entire case itself is demolished. When he says that there is a deed, registered deed, when he purchases the property from the same khata number 17, he is purchasing 21 decimals of land. So if he is purchasing, then obviously he is in possession on the basis of that itself. That is the finding of the trial.
There is a relinquishment deed also. Vendor has relinquished the right in the favor of these parties. It is also a registered deed.
And trial court issue number 10 also and issue number 7 also it came to a finding that we were in possession.
Who executed the relinquishment deed? Who executed the relinquishment deed?
That deed was executed by one Sumar. And he has relinquished the property in the favor of the Japanese.
Your Lordship, may I kindly take up the genealogical table? That would be easier. Therefore, I say. This is handwritten only for the purpose of what is the plaintiff's case and what is the defendant's case. Our case was that Gudo Mahato was the original. He had one son, Lalit Mahato, who is the recorded tenant, and he had two sons, Pannu Mahato and Gopal Mahato. Pannu Mahato died issueless, and rest are the descendants of Gopal Mahato. And then Somar Mahato, Udan Mahato and Hemant Mahato, they transferred the property by way of registered deed in the year 1993. And their
To the
case is,
plaintiff. Ajay Singh is the plaintiff?
yes. And their case is, this Gudo Mahato had in fact two sons. One was Lalit Mahato. Lalit Mahato's existence is not in dispute. Now Lalit Mahato, their case is Lalit Mahato died issueless, and therefore the entire property devolved on his brother. There was a brother named Damar Mahato, and then they are the descendants of. So both the courts ultimately
Who is
found
the
that-
defendant here? Deva Yadav.
Yes.
They are the defendant. These three, Ram, Tehel Mehto, Lukan Mehto, Ishwar Mehto, they are the defendants.
One to eight in the original suit.
राम टहल के डिसेंडेंट्स, लुकान महतो के डिसेंडेंट्स, ईश्वर महतो के डिसेंडेंट्स, ईश्वर महतो। ईश्वर महतो के डिसेंडेंट्स have not joined. आप उनको बस इतना बता दीजिए भाई ये सब्सटेंशियल क्वेश्चन ऑफ लॉ का हम क्या करें। Both the parties were at loggerheads so far as point of possession is concerned. Both the parties claimed possession of it. Yes or no? क्लेम तो किया था ना?
क्लेम किया तो क्लेम तो उनका तो मान ही रहे हैं कि जो परचेज किए हैं उसका पोजीशन में वो है, उसका कहाँ हम डिस्प्यूट कर
ये
सकते हैं?
डिफेंडेंट है ना?
हाँ डिपेंडेंट है,
डिफेंडेंट तो बोलते हैं सारा ही प्रॉपर्टी मेरा है।
सारा है, लेकिन उसी से फिर बोलते हैं हम खरीदे भी हैं।
ये खरीदे भी है लेकिन एज ए डिसेंडेंट भी है।
ऐसे कैसे हो रहा है? यही तो उसी का टाइटल डिस्प्यूट कर रहे हैं, उसी को बोल रहे हैं कि he does not admit that they were the owners or we are the co-sharers. वो नहीं बोल रहे हैं, वो बोल रहे हैं मेरा वेंडर का ही टाइटल नहीं था और उसी से
लेकिन आप पोजीशन में है।
हाँ,
तो ठीक।
अगर वो डीड नहीं रहता तो मेरे लिए प्रॉब्लम था, लेकिन वो डीड तो है। He says that Lalit Mahato died issueless, and from the person who died issueless, from his descendant they are purchasing. Therefore, they are in possession of 21 decimal. Have they said that apart from 21 decimal which we had purchased, then we are?
एडवोकेट का कुछ किया नहीं जा सकता।
हाँ नहीं, they should have said that we apart from 21 decimal which we had purchased, apart from that we are in possession. They do not say
They say that they are in possession of
That-
the
that
entire
is all.
property. Wrong मतलब कहाँ से बोलेंगे wrong? आप तो बोल दिए wrong. Judgment से देख के नहीं बोल पाएंगे. Possession पे dispute है, नहीं decide किया. नहीं है कोई decision. Appellate court तो बिल्कुल ही silent है. आप लिटिगेंट को छोड़िए बात, आप बताइए कहाँ है फाइटिंग एज एन एडवोकेट? बताइए, आपका जूनियर बहुत ज्यादा तैयारी किया, कहाँ है
नहीं,
फाइटिंग?
वो 3 जगह ट्रायल कोर्ट तो 3 जगह फाइंडिंग है कि वन पोजीशन, इसमें कोई डाउट नहीं है।
एपिलेट
हाँ, एपिलेट कोर्ट में ये स्पेसिफिक वर्ड नहीं है, बट इट हैज कॉन्कर्ड विद द फाइंडिंग ऑफ द ट्रायल कोर्ट।
कॉन्फ्रेंस में पोजीशन में भी तो कॉन्फ्रेंस लिखते हैं ना भाई, राइट टाइटल इंटरेस्ट एंड पोजीशन।
देयर इज नो सच थिंग एज परफेक्शन। एक जजमेंट, हम आज अगर 20 स्टेट भी बैठ के लिखे कोई चीज, तो आई वुड फाइंड अनदर पर्सन वुड फाइंड अ imperfection in my writing. तो
बस सही है।
the overall judgment effect of that question of law on the rights of the parties have to be seen.
जब बंदा एकदम स्पेसिफिकली रेस कर रहा है कि मेरे पोजीशन को कंसीडर नहीं किया है, तो कहीं से तो दिखाइए कि भाई यहाँ से लग रहा है कि इनका पोजीशन को कंसीडर किया।
हाँ, तो वो ये में है, एक तो डीड हम बताए,
डीड छोड़ दीजिए ना, डीड नहीं, आप
डीड हम
फाइंडिंग
छोड़
में
देंगे,
फाइंडिंग में लिखिए।
मेरा फाइंडिंग में ये आया था ना कि सुमर महतो
फर्स्ट
है,
एपिलेट कोर्ट के फाइंडिंग में, दोनों कोर्ट को तो फाइंडिंग देना है ना, राइट टाइटल इंटरेस्ट पोजीशन का,
हाँ,
है ना? ठीक है, बहुत ज्यादा नहीं लिखेंगे लेकिन कुछ तो लिखेंगे, और कहीं से तो कुछ डिराइव हम लोग करेंगे कि हाँ भाई इससे लग रहा है कि पोजीशन कंसीडर किया।
एपिलेट कोर्ट का तो हमको नहीं मिला।
नहीं है ना, तो फिर क्या, कैसे आप इस जजमेंट को अपलोड करेंगे?
Because substantial question of law would mean that it must be so vital for deciding a case that it overturns the answer to that, overturn the entire judgment itself. So here
मान लेते हैं इनकंसिस्टेंटली या डिफेंडेंट, मान लेते हैं डिफेंडेंट इज नॉट फेयर, मान लेते हैं डिसेंडेंट हैज नो टाइटल, पोजीशन इतना भी कोई इनकंसिस्टेंट नहीं है इनका डिमांड्स।
but possession ultimately Sumar Mahto was recorded to be in possession. The demand was running in the name of my vendor Sumar Mahto.
तो वही कंक्लूसिव एविडेंस हो जाना चाहिए।
तो नहीं, उसी को तो ये फिर कैंसिलेशन फाइल के उससे वहां से स्टार्ट हुआ।
और आपका जो है ना, the adjudicate the right title and interest of the plaintiff over the suit land, we declared, and the possession of the plaintiff over the suit land, we declared, we confirm.
Find dispossessed वाला।
And in the alternative, if the plaintiff is dispossessed, during the वो तो normal रहता ही है। तो not only that, possession was a direct issue in the suit.
Issue
was
was there, but
directly
the
an
trial
issue.
court has discussed. Appellate court separately does not discuss.
Indirectly also does not discuss. Let's take it. Even indirectly, that appellate court does not discuss. बताइए, भेज देते हैं appellate court में, ट्रायल कोर्ट में नहीं भेजेंगे, कोई तो डिस्कशन होना चाहिए ना। बताइए, सब 2016 का ये सब चल रहा है, इतना छोटा छोटा चीज को तुरंत डिसाइड करा रहे हैं।
हाँ हाँ, कर लेंगे, कल ही सुबह।
कल अब तो 7 मिनट बाकी है। अब क्या
7 मिनट में
हम तो बस 1 मिनट में बोलेंगे रिमांड और
नहीं, वो थोड़ा ज्यादा हो
वो
जाएगा।
ज्यादा हो जाएगा। ठीक है,
कल एज फर्स्ट केस
लिखिए, और the learned counsel for the parties, the sole point for the sole substantial question of law involved in the present case as recorded in order dated 5/2/2019 is inverted comma whether the possession of the defendants have not ever been considered by the trial court or that the learned counsel for the appellant while placing the judgment passed by the learned trial court, has submitted that an issue was framed as issue number 2 as to whether the suit is barred by law of limitation, waiver, estoppel, acquiescence and adverse possession, whose finding has been recorded in paragraph number 10 of the trial court's judgment. The learned trial court has considered the point of limitation but has not considered the point of possession, much less adverse possession. So far as the learned appellate court is concerned, a specific plea was raised that the learned trial court has not considered the point of possession of the defendant as recorded in the submission in paragraph 8 of the appellate court's judgment. But the perusal of the first appellate court judgment revealed that the point of possession has not at all been considered, and the learned first appellate court has recorded that the plaintiff has got right, title and interest over the suit land. He has submitted that the point of possession was directly in issue in view of the fact that the plaintiff themselves have sought a relief of confirmation of possession with an alternative relief if they are found dispossessed, the property be restored to them. The learned counsel submits that the substantial question of law is fit to be answered in favor of the appellant, and consequently the matter is to be remanded to the first appellate court for consideration.
So far as the possession issue is concerned,
Only on
it has
the
even no finding by the trial court also.
Okay, we have already recorded that. So first appellate court को जाएगा ना? First appellate court, which is the final court of fact and law. The learned counsel
Issue of
further.
limitation I have also said. The suit is of the lead is of 1929.
The learned counsel has also submitted that the point of limitation has also not been properly considered by the learned trial court, and therefore an issue arises in this case
At page 15 of the memo.
at page 15 of the memo of appeal.
Whether learned appellate court might
Grounds a substantial question of law number E. And he submits that additional point we also framed for consideration. The learned counsel appearing on behalf of the respondents has opposed the prayer and has submitted that the point of limitation has been duly considered by the learned court, and the learned court has given the benefit of the fact that the plaintiff was pursuing the matter before another court, and ultimately when the matter was and ultimately pursuant to the order passed by the court, the suit was filed.
And section 14 strictly
And
applies.
has submitted that section 14 of the Limitation Act applies, and the same principle has been applied by the learned court while considering the point of limitation. So far as the substantial, he submits that the substantial question of law on the point of limitation as argued by the learned counsel for the appellant does not arise, and therefore no such substantial question of law be framed and decided. The learned counsel has further submitted that so far as the substantial question of law with regard to possession is concerned, the learned trial court has discussed the same finding under issue number
7 and 10.
issue number 7 and 10, 7 and 8 perhaps.
7 is at page 17.
Issue number 7.
and 10 is at 9. 9 as last issue decided by the page 19. But main is as page
Issue number 7 and 8. एक साथ
7.
decide. Issue number 7 and 8, which has been decided together by the learned trial court by paragraph number 8 onwards. He has submitted that at internal page 17 of the trial court judgment, it has been recorded that name of Gopal Mehto finds mentioned in register 2, and he is in possession over the suit land also. But despite this, demand has been cancelled in the name of Somar Mehto, who was son of Gopal Mehto.
Yes. So,
So far as the learned first appellate court is concerned, the learned counsel has submitted that since there was a judgment of affirmation, there was no need for further discussion. The learned first appellate court, having found right, title and interest of the plaintiff over the suit property, has dismissed the appeal and confirmed the judgment of the learned trial. He has submitted that he shall advance his arguments for the tomorrow. Substantial वो नहीं बनेगा आपका, limitation नहीं बनेगा. अभी reject कर दो.
section 14 says suit.
नहीं, उसमें तो-
Uses the word.
नहीं उसमें कोई दिक्कत नहीं है. The learned
Due diligence word is. So 42 देखा है.
due diligence is also will depend upon the appreciation of fact. Second appeal में नहीं सुनेंगे.
इसमें उनकी बन सकता है. ये बनेगा.
और appellate first appellate court में तो आपने point of limitation को raise भी नहीं किया.
देखिए
नहीं किया.
उन्होंने खुद भी इस पर दिया.
नहीं
पर एक उसका डिस्कस भी किया.
He should have raised that it was not due diligence. Before
बहुत
the,
सा चीज़ है. In computing the period of limitation for any application, the time during which the applicant has been proceeding with due diligence, another civil proceeding, whether in the court of first instance or appeal or revision against the same party for same reason, shall be excluded, where such proceeding is prosecuted in good faith in a court, which from defect of jurisdiction or other caused like nature is unable to entertain. ये चीज तो कैंसिलेशन ऑफ डिमांड का ही कर रहे थे. उसको उनको तो उसी समय अच्छा. और जब इनका रिलिंक्विशमेंट डीड 1995 में इनका वेंडर हमको लिख दिया, तो नहीं रिलिंक्विशमेंट डीड का कैंसिलेशन के लिए लाए, ना अपना डिक्लेरेशन ऑफ टाइटल के लिए लाए. अभी आके ये 2007 में कर रहे हैं. एब्सोल्युटली बार्ड बाय लिमिटेशन होगा. हाउ द ऑर्डर्स पास बाय द ऑनरेबल
एक बात बताइए, जब ये पॉइंट ऑफ लॉ बना होगा तो आप चुपके थोड़ी होंगे सब कहानी सुनाने.
पॉइंट ऑफ लॉ
कोर्ट नहीं एग्री हुआ होगा आपका ये पॉइंट ऑफ लॉ में. आपसे तो ऐसी चूक एक्सपेक्टेड ही नहीं है. जब आपने
फ्रेम किया है, अगर नहीं किया होता तो नहीं.
फ्रेम किए हैं, लेकिन फिर भी क्वेश्चन, फिर भी कोऑर्डिनेट बेंच ने उसको नहीं फ्रेम किया.
Appellate court में हुए तो particularly when two courts are they have declined in the case of
नहीं ये सब नहीं.
उस particular case में it's always difficult to argue from the side of the other. जो भी admit होने का position रहता है, my friend will not.
गलत है ना ये.
हो जाए.
ये सोच ही गलत है ना कि किसी तरह से एडमिट करा लिए फिर झेलिए.
नहीं दिक्कत.
नहीं
लेकिन ये point of law है.
नहीं है पॉइंट.
Point of law.
I'm just
This
trying to
court-
find out one judgment
इट्स अ मिक्स क्वेश्चन ऑफ फैक्ट एंड लॉ. ये तो एकदम ही
Honorable Supreme Court, where the Honorable Court had held, deciding section 14, what would be section 14? Videocon, the party's name was there. And in that it was held that once the a proceeding was filed, and then it has to be assumed that it was bona fide. It was bona fide. Merely because there was another proceeding, that would not make it absolute separate. I'll just, I'm trying to find out.
ये हाई कोर्ट के ऑर्डर के बाद ही आपने सिविल कोर्ट में
Section
किया है।
5
हाई कोर्ट के ऑर्डर के बाद
हाँ,
किया है।
section-
हाई कोर्ट में हाई कोर्ट ऑब्जर्व किया, आप जाके सूट फाइल करिए।
सेक्शन 5 का लिमिटेशन
5 तो नहीं लगे,
होता ही नहीं,
वो तो नहीं
अगर
लगेगा।
5 भी अप्लाई नहीं करेगा तो 14 कहाँ से करेगा?
नहीं कैसे नहीं बोल रहे हैं, दो अलग अलग। मिस्टर
14
शर्मा
से-
प्लीज डोंट टेल मी दिस। हम
In computing the period
देखिए
of
एक चीज बता
limitation
रहे हैं
for
मिस्टर
any
शर्मा,
suit.
when you make such a submission तो मुझे लगता है either you think that I am a fool कि सेक्शन 14 and 5 का मतलब एप्लीकेबिलिटी हमको समझ में नहीं आ रहा है। 5 नहीं अप्लाई करेगा तो 14 नहीं अप्लाई करेगा। ये कहाँ से लेके आए हैं आप?
तो अप्लाई करता ही नहीं।
5 नहीं करेगा, हम तो खुद भी, हम
तो
कहीं
कहाँ
बोल
से
भी नहीं
करेगा?
रहे।
5 does not apply.
रह गया
14 तब तो यहाँ जो आप रीट में ऑर्डर लेते हैं that I will agitate it in the suit तब बंद हो जाएगा सब। आप ऐसा कुछ प्रोनाउंसमेंट कराइए।
इसमें 14 का एप्लीकेशन जिस तरीके से चाह रहे हैं वैसा नहीं हो। अदरवाइज तो हाई कोर्ट तक लड़ते रहिए, फिर 0 से स्टार्ट करते, कभी लिमिटेशन का कोई इशू नहीं।
इसीलिए जब भी हम डेलीगेट करते हैं किसी को भी सूट के लिए तो उसमें दो चीज़ ज़रूर लिखते हैं। एक तो किस दिन फाइल हुआ और किस दिन डिस्पोजल। डिस्पोजल का तो डेट रहता है, ये फाइलिंग का डेट भी बहुत इम्पोर्टेंट है। ये वो सेक्शन 14 का कहानी
ये हम दूसरा रीजन बोल रहे हैं, इस केस के लिए हम नहीं बोल रहे। माई ओनली वन सबमिशन नाउ बाय एनी प्रोसीडिंग इफ अल्टीमेटली इट इज हेल्ड दैट because there is a remedy of suit you go for a suit, then my first remedy is being rejected on the ground that I have a separate remedy, then I cannot in the second proceeding, now this cannot be a ground that no it was not।
इसका 14 का 3 देखा जाए, अगर कोई सूट अगर कोई फाइल है उस पर्टिकुलर केस में अगर परमिशन ले लेते हैं तो उसमें लिमिटेशन नहीं लगता, लेकिन अगर कोई प्रोसीडिंग आप सुप्रीम कोर्ट तक लड़े वहाँ से अगर आप उसके बाद फाइल कर रहे हैं तो उससे लिमिटेशन कम से कम इस वजह से तो कंडोन नहीं है। ये ड्यू डिलिजेंस इसको माना नहीं है। अगर 93 में when you were aware about the proceeding, you intervened. What prompted you not to file a suit in the year 1993 or 95 में कैंसिल भी तो कर, कैंसिल के बाद भी नहीं आ रहा। You were waiting for the results of the High Court, and that you up to the LPA order. ये इसका पल्स नहीं है जो सेक्शन 14 का। Regards of the limitation will apply in the strictest possible manner. That would be in the interest of justice also, as because litigation को आप कैरी ऑन करते रहे। अगर सूट फाइल होता तो आज भी डिसाइड होगा, इतना दिन के बाद ये डिसाइड होगा। ये इशू मेरे समझ से दिस इज ए पॉइंट ऑफ।
आपने अपने आर्गुमेंट में भी नहीं लिया है दैट इट इज बार्ड बाय लिमिटेशन। आप जो बोले ना कि लिए हैं फर्स्ट एपलेट कोर्ट में, दिखाइए पैरा 8 में। योर ओनली इशू वाज रोमन 7 and 8 and it is a mixed question of fact and law. हमने इसका कोई फाइनेंस कोई सब्सटेंशियल क्वेश्चन नहीं था, इट इज नॉट अ प्योर क्वेश्चन। बताइए पैरा 8 में कहीं लिमिटेशन का नाम भी नहीं है।
There are two Supreme Court judgments here. One was consolidated engineering reported in 2008, in which only one line I am reading. While considering the provision of Section 14 of the Limitation Act, proper approach will have to be adopted and the provisions will have to be interpreted so as to advance the cause of justice rather than to abort the proceeding. It will well bear in mind that an element of mistake is inherent in the invocation of Section 14.
आप एक बात बताइए, ये तो तब ना होगा जब हम लिमिटेशन का इशू बनाएंगे।
हाँ।
हम तो बना ही नहीं रहे।
नहीं ठीक है because
I'm not
he's
at all
pressing
saying
so
ये
hard on
limitation-
that, therefore
नहीं, वो तो बनाएंगे तो फिर डेट देना पड़ेगा, वो तो हम नहीं करने वाले। लिमिटेशन का जो आपका एपेलेट कोर्ट में जो ग्राउंड्स है उसमें है फॉर दैट द लर्नेड ट्रायल कोर्ट डिड नॉट कंसिडर द इशू ऑफ लिमिटेशन ऑन द ग्राउंड that both the parties were residing or resident of the same village and should necessarily be knowing the state and other papers or possession in the parties in the revenue. यही है.
ये भी हमने लिखा है सब्सटेंशियल क्वेश्चन ऑफ लॉ हमने
Substantial question of law ऐसे नहीं बनता है ना. Limitation is a mixed question of fact and law. Primarily, in a very very rare circumstances, it is a pure question of law.
But he has intervened in the matter. That point I have it in the appellate court judgment also. In the appellate court of
Intervention allow हुआ था. नहीं ना पता है.
But he had knowledge in the year 1994.
लिखिए, so far as the framing of additional question of law is concerned, this court finds that the learned trial court has scrutinized the materials on record and recorded a specific finding in paragraph 10 that the plaintiff ultimately approached the civil court when the division bench of the High Court dismissed his case arising out of the mutation proceedings with a direction to approach civil court of competent jurisdiction for adjudication of title. The suit was filed in the year 2007 itself. This court finds that the learned trial court has this court finds that in the present case the finding on the point of limitation has been duly arrived by the learned trial court, and the point of limitation in the present case is a mixed question of fact and law. And accordingly, no substantial question of law arises for consideration so far as the point of limitation is concerned. From the perusal of the first appellate court judgment, this court finds that no specific argument was advanced in connection with the point of limitation. Though in the memo of appeal, the appellant had raised a ground that the learned trial court did not consider the issue of limitation on the ground that both the parties were resident of the same village, should necessarily be knowing the state and other papers or possession and the parties in the revenue. The learned, as recorded by the learned trial court's judgment, the limitation was considered by referring to the order passed by the High Court asking the plaintiff to get his title declared. This court is of the view that no substantial question of law in connection with the point of limitation is involved. So prayer is written. अब कल जो है पोजेशन का कहानी सुनाऊंगी.
I'll take only 2-3 minutes.
3 minutes.
Specific I have to reply.
हाँ specific आप
हाँ
एकदम पैरा
I'll
नंबर
not waste your lordship's time.
tomorrow at 10:30, correct? कोई orders है आप लोग का?
ऑर्डर्स में अगर तो नोटिस है fact you wrongly listed है.
अच्छा.
It should have been listed under the order 41 order.
अच्छा, तो इसको appropriate heading में डाल देंगे. कभी भी.
हाँ.
So,
हाँ, बोलिए.
in this case, if the memo of bill is concerned, my learned petition was supplied, only petition has been supplied. I have requested my client, he supplied the same today itself.
नहीं नहीं, आपका तो अभी substantial question of law बना ही नहीं है, तो आपका कोई रोल ही नहीं है.
Even though I should go through all those things, at least the time of framing.
नहीं, कोई जरूरत नहीं है.
So,
Not required.
I have already appeared in this case, my lord. I have already filed IA, a reply of the IA, my lord, filed by stay, my lord. In that case, I have
Stay
already-
तो हम सुनते ही नहीं.
That is the reason, my lord. I have to assist the court, my lord. That is the reason.
आप CPC देख लीजिए. फिर substantial question of law frame करने के लिए respondent की कोई जरूरत नहीं है.
That is there, my lord. I know. But because a stay petition has been filed, that is the one of the reason I have replied already, and I have taught all.
Stay नहीं सुनेंगे. आगे record आपका.
रिकॉर्ड मेरे पास
Record नहीं आया.
नहीं है.
Concurrent finding है.
Yes.
आप कौन हैं?
हम हैं डिफेंडेंट.
Title suit है.
Title suit for declaring the sale deed null and void by which I had purchased the land. 5 decimals of land I had
आप बोल
purchased.
रहे होंगे टाइम बाद है.
नहीं
Time
तुरंत
बाद.
तुरंत
The
किया गया.
factual aspect is otherwise, my lord. There is two brothers,
फिर
cousins.
भी पौने 5 आज appropriate heading में आने दीजिए. दे दीजिए भाई उनको. देखिए ऊट पटांग.
हम मेमो ऑफ अपील दे भी दिए हैं.
मेमो अपनी कहा दिया आपके पिटीशन
आप
दिए
दे
दो बार
दीजिए
रिक्वेस्ट
उनको.
तो नहीं देते हैं
Memo
आप
देखिए एक चीज बता रहे हैं. It is the responsibility of the councils कि substantial question of law ढंग से frame. हमारे ऐसे सिचुएशन आ रहे हैं जिसमें substantial question of law frame हो गया है. Concurrent finding है that the suit is barred by limitation. तो हम क्या करेंगे उसका? हमको in spite of deciding that the substantial question of law is क्योंकि frame हो गया तो हमको decide करना है. और लास्ट में बोलना है कोई रिलीफ नहीं दे सकते because there is concurrent finding on limitation. ठीक है, वो तो हम जब जजमेंट लिखते हैं तब पता चलता है. वो आप लोग नहीं देखते हैं तो बस. कितना सीरियस है?
एक मिनट समय लगे.
हाँ
एक
एक मिनट
मिनट, सिर्फ एक.
आप बोलिए.
दूर यहाँ पर मैटर है वो क्या है हम पर नर्सल बता. एक उधर सुन ले. डिपेंडेंट जो है यहाँ दो ब्रदर के बीच पार्टीशन सूट फाइल होता है. पार्टीशन कंप्रोमाइज हो जाता है और उसके बाद पार्टीशन अपील फाइल होता है, वो भी कंप्रोमाइज होता है. और ये कहा जाता है कि ये जो है ज्वाइंट पोजीशन वाला लैंड है, इसको कोई सेल आउट नहीं कर सकता. उस लैंड में से एक भाई जो इलिटरेट है उससे किसी तरह से प्रोक्योर कर लिया शायद और वही रजिस्टर्ड डॉक्यूमेंट है. जब ये कोर्ट का फाइंडिंग आ गया ये नल ज्वाइंट नहीं किया जा सकता है.
इलिटरेट आदमी बेच नहीं सकता है
नहीं
क्या?
सर, बेचने के बाद जो ज्वाइंट है दिस इज द डिसीजन ऑफ द डिवीजन सॉरी अपीलेट कोर्ट saying that the land is concerned, so plot number 101 is concerned, that is a joint property that cannot be sold by anyone.
Cannot be sold by anyone
The
मतलब
को jointly enjoy करना ये this is the finding of the court value that is there in the light of खतियानी रैयत.
भाई अनडिवाइडेड पोर्शन नहीं बेच सकता आदमी.
अभी जो कोर्ट का फाइंडिंग है वो नहीं तक आपको फाइंड करा रहे हैं, उसमें ये फाइंडिंग है वो नहीं बेच सकता है. और यही कारण था कि ये जो है जो जिसका फोर्स डॉक्यूमेंट से खरीद लिया गया है वो है टाइटल सूट फाइल किया जो कि अलाउ हो गया. उसके बाद ये अपील फाइल की, वो डिसमिस हुआ, तब ये लोग आए. उस 5 डिसमिल जमीन जो फोर्स लिया गया है उसी को डिस्प्यूट कराया जा रहा है.
हमको तो आज तक ये समझ में नहीं आ रहा अभी तक कि कैसे कोई ऐसे इंजंक्शन लग सकता है कि आप बेच नहीं सकते. हाँ, उनका राइट टाइटल सब खत्म.
हम ये तो अब
Factually
दिखाएंगे
incorrect
हम
statement.
दिखाएंगे जजमेंट दिखा देंगे.
ना देखिए
जब देखेंगे उस समय पर
कि रेस्ट्रेन ऐसा कोई रेस्ट्रेन ऑर्डर पास हो सकता है कि आप बेच नहीं सकते. तो ऐसे ही बात है.
मेरा सेपरेट प्रॉपर्टी रहेगा तब ना ज्वाइंट प्रॉपर्टी का
जॉइंट
मामला.
प्रॉपर्टी बेच सकते हैं, कहाँ मनाएंगे?
नहीं, उसके बाद भी अगर हमारा वह क्लेम है और हमने एस्पेक्ट टाइटल सूट फाइल किए हैं कि मेरा फोर्स डॉक्यूमेंट साइन कराया गया है,
वो अलग बात है. फोर्जरी की कहानी
ये
है.
फाइल किया गया सूट पे.
और जरिए की कहानी जो बेचा है वो इनके लिए बोल रहा है.
नहीं नहीं ऐसा क्या
तो
हमारा
factually
भाई,
दिखाएंगे.
हम दिखाएंगे.
Yes.
रिकॉर्ड में दिखाया.
रिकॉर्ड में
तो कुछ ज्यादा ही लड़ रहे हैं.
रिकॉर्ड में
दोनों को सुन के ही बनाएंगे हम क्वेश्चन ऑफ लॉ. ठीक है.
एक्चुअली देखा था कि जो वहाँ फ्रॉड कर रहा है
हाँ वो
कर रहा है,
दिखाएंगे रिकॉर्ड का चीज. हम कोर्ट से जजमेंट से बाहर नहीं जाए, कुछ भी नहीं एक शब्द.
लग रहा है अभी 10:30 बजे, इतना आप लोग लड़ रहे हैं।
अब नहीं disturb करें।